funding agreements in certain circumstances and requiring reporting of such agreements to the Judicial Council for study. And with that, then, a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 54 amends KSA 6226. That's the statute and the rules of civil procedure that is related to the discovery rules. The bill provides that a party may obtain discovery of the existence and content of any third-party agreement subject to specified limitations throughout the bill. Third-party agreement is defined as any agreement under which any person other than a party, an attorney representing the party, such attorney's firm, or a member of the family or household of a party has agreed to pay expenses directly related to prosecuting the legal claim and has a contractual right to receive compensation that is contingent in any respect on the outcome of the claim. That term does not include an agreement that does not afford the non-party agreeing to pay legal expenses any profit from the legal claim beyond repayment of the amount such non-party has contractually agreed to provide, plus reasonable interest. And that reasonable interest is defined in the bill as 11.1% of the principal. On motion, a court shall prohibit any inquiry into the existence or non-existence of a third-party agreement on finding by a preponderance of the evidence that that inquiry may cause undue prejudice to the party objecting to the inquiry. Information concerning the third-party agreement is not by reason of disclosure admissible at trial. Unless the court finds that a third-party agreement would be admissible under the rules of evidence and necessary to prove an element of the claim, then disclosure shall not be required in any action brought by or on behalf of the state or any political subdivision of the state enforcing a law or seeking to protect against imminent threat to health or public safety, or solely in the public interest or on behalf of the general public if certain criteria are met that are in the bill. When requested by the disclosing party, the court shall issue an order to protect discovery of a third-party agreement from disclosure other than to the parties, the counsel, experts, and other necessary personnel to the legal claim. The bill also requires reporting of third-party agreements to the Judicial Council on and after July 1st of 2025. Any third-party agreement under which a person has a contractual right to receive directly or indirectly compensation that's contingent on any respect of the outcome of the claim shall be reported to the Judicial Council within 45 days. The Judicial Council shall provide the person who reported that documentation showing, like a receipt showing that that report was made. Any third-party agreement that is not reported would be void and unenforceable unless that agreement relates to the specified actions that we talked about earlier. The clerk of the Supreme Court would be required to prescribe a form for this reporting, and the reports received shall be confidential and not subject to open records. Finally, the bill requires the Judicial Council to create a committee to study third-party agreements. On or before July 1st, 2028, the Judicial Council has to establish that committee that's required to review all the third-party agreement reports submitted and any information related to those agreements. Beginning December 1st of 2029, and then each December 1st thereafter, the Judicial Council would be required to report to the Chief Justice of the Supreme Court, the Attorney General, the House Standing Committee on Judiciary, and this committee on the topic of third-party agreements in Kansas, and then make any recommendations related to that. And I can take any questions.
Thank you. Committee, any questions? Yes, Senator Shane.
Thank you, Madam Chair. Thank you so much for going over that for us. Just one question I have. So right now, the bill is drafted with states that the court could prohibit any inquiry into the existence or non-existence of a third-party agreement. And then we also have in here that there's a prescribed form. Wouldn't a motion requesting the non-disclosure disclose the fact that there's a third-party funder? Or do you would see that as a potential risk in the process if the intent is, if the knowledge of having a third-party funder could have an influence or sway or create prejudice in the case, that by default would prevent the non-disclosure in a sense? Do you understand what I'm asking?
Thank you, Madam Chair, Senator Shane. I think I do understand what you're asking, but I think it's more of a policy question, and I think it would probably be better directed at the conferees to say, you know, whether they think that might be a repercussion and whether that is good policy or bad policy.
Okay, thank you.
Well, thank you for the very thorough briefing, and I think we don't have any more questions. So we do have a number of proponent and opponent conferees, so want to make sure that we also have time for questions. So we're going to limit testimony of each conferee to 7 minutes, and I will hold up the manila folder when there's 1 minute remaining. So please follow along with that as well. So with that then, we will invite our first proponent conferee to the podium, Eric Stafford, Vice President of Government Affairs, Kansas Chamber of Commerce. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. Eric Stafford with the Kansas Chamber, and appreciate the opportunity to be here today in support of Senate Bill 54. Rumor has it this morning, unfortunately bad Super Bowl, that John Federico placed a very large bet on the outcome for Philadelphia to win. You know, let that create question in his judgment. Love you, John. So this committee has a lot of new faces, and I'd like to give some background. This is not a new issue to the Kansas Legislature for consideration, but some of the new faces might be asking, what is a third-party funder? What is a third-party agreement? What is litigation funding? And what we're talking about today are hedge funds that invest in litigation. These firms have teams of attorneys who research lawsuits from across the country to decide and find what might provide the greatest return on their investment. So what are they investing? Sometimes tens of millions of dollars, sometimes hundreds of millions of dollars, depends on the case. But it's a relatively new industry. Where estimates place it about $15 billion already. It's only been around for about 15 years in the United States. First started in Australia and then moved to Europe and now America. The downside of this practice, when they're looking to make that return on investment, if they feel like that return on investment is not significant enough, they can put pressure on the plaintiffs to continue pushing and rejecting settlement offers from the defense, which in the case from the business community raises costs to the business, raises insurance premiums for everybody. If you have a very litigious society, premiums will be higher. There is a correlation between the tort climate in a state and the insurance premiums that individuals pay in those states. That cannot be denied. So if these third-party funders have no claim to the litigation other than the agreement to pay legal fees up front, the relationship between the attorney and the client should not have any outside influence. But if you look at the article, I believe it's at the bottom of page 1 of our actual written comments, there's a Wall Street Journal article from a couple years ago that you can click on and read, where one of the biggest funders did just that against a food supplier who was suing producers for price fixing. So states have started to take action on this, requiring disclosure. Some states have more restrictive language than what is before you today in Senate Bill 54. Some federal district courts have put this disclosure requirement in their rules, and some have not. So there's a second article, another more recent, December of 2024. It was a Q&A where there was a gentleman who heads up a risk management organization, and he talks about what is actual justice. And what he stated in that question and answer, he said that's not what most people would consider justice. If these hedge funds are taking the bulk of the award, and then they have the attorney's fees on top of that, then you're going to leave the actual injured person with not that much money, but it's going to be a potentially big settlement. I think the Monsanto case out in California, pesticide case, was a $400 million, $450 million settlement. How much of that goes to the person who was actually damaged, and how much went to attorneys and hedge funds? So we're not here today asking to ban the practice. We're not here to ask them to register with the state and go through steps that create regulation and bureaucracy. This is America. We are free market and believe in capitalism, but in terms of transparency and disclosure, we believe disclosure at minimum, when there are potential influences to the case for financial gain, that should be disclosed so all parties can have a full understanding of what the picture looks like in the litigation. Just like in existing law, plaintiffs have the ability to have insurance limits disclosed so they can make a determination of whether to settle or pursue litigation against who wronged them or damaged them. So our language before has changed significantly from previous versions. What you have today before you is very similar to House Bill 2510 that passed the House last year, end of last session, with 23 votes. Unfortunately, we ran out of time to get that done. But this language is significantly different in that we for the first time, as we've been working on this, had the Attorney General's office last year testify out of concern of public interest and nonprofit litigation, and that is where the language significantly changed. It was intended to protect the nonprofit, public interest, social-oriented type litigation. If there might be a donor, say, I want to give $1 million to name the cause, right? Treatment of animals, guns, abortion, whatever it might be, and I'm not seeking to profit off of that. That is a different scenario than what we're talking about here. So it took about 2.5, 3 weeks to negotiate that language with the AG's office to get them where they were comfortable, and so that is, I think our language was a paragraph before, and now we have 4 pages. So it is significant. So on that front and on that vein, I have, leading up to this hearing, heard from 2 nonprofit attorneys reached out of the blue, or attorneys with interest in nonprofit litigation. They asked that the committee adopt changes to the definition. Right now it says third-party agreement. They asked to tighten that down to say third-party litigation funding agreement throughout the bill instead of third-party agreement. And then also the judicial reporting requirement that was added last year in the House Committee for the Judicial Council. Nancy sent us from the Kansas Judicial Council, sent us language that is included on our testimony that they asked for clarification in some of the language there. So we would ask that the committee, if you move forward with this legislation, make those 2 changes. And is that 1 minute left? Okay, thank you very much. So we are fine with their language. The Judicial Council, I think it probably provides some pretty good cleanup to what is in there today. And then finally, I'll close with the change. This is not exactly identical to House Bill 2510. 2510, as passed by the House, had 2 sunset provisions that are not in there. One of them being the reporting requirement, and then the second one being the actual disclosure. Both of those would have sunset after 5 years, and we don't really carry the way on the reporting requirement. That was something the AG's office asked for. So if we're going to maintain that and continue it, please adopt the language that the Kansas Judicial Council provided to clean that up. But we do believe that disclosure is a very low bar. It's a fairness issue. And Madam Chair, I'm happy to answer any questions. I know there'll be some other experts who will speak today on how this actually impacts litigation. So thank you for the opportunity to be here today, and happy to answer questions at the appropriate time.
Thank you. We're going to hear from all proponent conferees, and then we're going to take questions from committee. So next we will hear from Philip Davidson, Hinkle Law Firm. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. If it pleases Madam Chair and the committee members, my name is Philip Davidson. I'm the head of litigation at the Hinkle Law Firm. We're a law firm of about 50 lawyers. We're based in Wichita, Kansas. We also have an office in Lenexa, Kansas. I'm a graduate of the University of Kansas and the Washburn School of Law. I've practiced for about 35 years. I've handled primarily civil defense cases, although I've handled plaintiffs' matters as well. I've handled over 5,000 cases in litigation in over 30 states. Most of those cases get resolved in an arbitration or mediation, primarily mediation process if it doesn't go to trial or get otherwise dismissed, but the vast, vast majority get resolved in mediation. I'm not new to this issue, but I was fairly new to the bill that's been proposed, and we're a proponent of Senate Bill 54. I want to give you some background and then leave a little bit of time for questions if you might have them. Typically in discovery, which is one of the first phases of the case, both sides exchange interrogatories and requests for production of documents. And that's very common in federal court. It's an initial disclosure that's required where you have to voluntarily provide those types of documents. In all cases, the plaintiff will ask for any insurance agreements, coverage limits, things of that nature. That's been the case my entire career and for many years prior to that. So they'll ask, who's the insurance carrier? Let's see the insurance carrier's claim file. What are your coverage limits? And are your coverage limits eroding? What an eroding coverage limit is where you say have $100,000 of coverage, as an example. Defense costs come out of that. So that coverage that the insured has is reducing over time. If it takes $100,000 to defend the case with experts and depositions and all that, we're typically paid hourly and bill monthly. So that coverage is coming down. These types of agreements are very analogous to that. These types of agreements increase in the value of the claim to the for-profit entity who's provided the financing in the agreement. So on the defense side, where the plaintiff wants to know early on, is the policy eroding? On the plaintiff side, we want to know is the value of the case to the plaintiff's attorney and to the uninterested, except for financial purposes, third party, is that dollar amount going up, which has nothing to do with the facts, the law, or the otherwise value of that case to a mediator or to a trier of fact, in most cases a jury. So from that standpoint, this is something that I've felt that on the defense side, it's very appropriate to disclose what coverage limits you have, or if you do not have coverage, or whether the coverage has a reservation of rights, which is where an insurance company will potentially put restrictions on the coverage based on the policy vis-a-vis the insured. So this is very, very common. On the plaintiff side, it's kind of behind the curtain. You don't really know what's going on. And so I agree with our first presenter that it's a very low bar to make this initial disclosure. And Senator Shane, I believe, had a question with regard to if there's a motion by the plaintiff's attorney to withhold the disclosure, does that not indicate that there is a disclosure? That type of process happens all the time. And the court can look at that in camera. Yes, the other side is going to know there maybe is an agreement out there. They're not going to know for sure. It would be my sense, looking at the bill, that the court would be encouraged to require the disclosure of the agreement, so both sides basically have the same kind of information with regard to how the case is going to proceed, whether there should be an attempt to settle the case early, that type of thing. From a practical standpoint, mediations sometimes occur early. They usually occur later in the case, after a lot of money has been spent on both sides and effort, and the opportunity cost to a defendant where they're preparing the case and participating in discovery and that type of thing when they're not focused on, say, their business. All those costs are already incurred. Many times these funding agreements, even to the plaintiff's attorney, are not known to the plaintiff's attorney until the mediation, where they say, we're talking about fair value. Mediator comes in and says, oh my gosh, we got a real problem. They basically have a $50,000 lien that they have to pay back first, which is this financed product that sometimes the plaintiff will have without disclosing it to their attorney. And so the attorney's learning for the first time that, and certainly the defense is learning for the first time, that this is going to be an issue. It artificially inflates now the value of the case if the case is to be settled, because that's a piece of compensation that's got to be paid before the plaintiff's attorney and before the plaintiff. So it reduces the recovery to the plaintiff. It's my view, most people will only tell me this off the record from the plaintiff side, that they always ask and they always know. But in practice, from mediations, I've heard from many plaintiff's attorneys and mediators where they say the plaintiff's attorney didn't actually know that their client had called a referral service that you see on TV. They say, oh, you've got a great case. It's going to be worth at least $100,000. And we can give you a loan for $10,000. Well, the annual interest on that may be 100%. So as they go down the road, the case gets very difficult to settle for what otherwise would be fair value. And if the defendant settles, they're in a sense funding that financed piece of the case. Because they say, well, we don't want to go to trial. It's too expensive. It's too uncertain. And so instead of paying fair value, which they won't take because they've got this lien, we'll pay the fair value plus the lien. So I think what the Judicial Council is going to find is that this is a very, very inefficient and inequitable process. Sounds good on the front end that a plaintiff who feels they've been aggrieved could get some money up front. But at the end of the day, I believe what the results are going to show and what a lot of the literature says is that it's an unsatisfying result at the end. And most mediators, off the record, will also tell you that it's one of the worst things that they find when they're mediating a case. So if they get through half the mediation and you're getting close, and then the plaintiff's attorney or the plaintiff says, oh, by the way, I've got this lien out there, which is this financed obligation. So that's a huge practical impact, and I think this bill is very skinny from that standpoint as far as the obligation of the plaintiff's attorney to want to acquire the knowledge what his client's done or what he's done for the client from a financing standpoint, and then disclose that to the other side. There's a lot of safeguards in here for that ever being admissible at trial, such as insurance is not admissible at trial. With that, I would invite any questions.
Thank you. Committee, now we will next invite Daniel Murray, Kansas State Director, National Federation of Independent Business. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Dan Murray, the Kansas State Director for the National Federation of Independent Business. NFIB represents nearly 4,000 small business owners across the state. We are the voice of small business and appreciate the opportunity to provide some brief comments today. The two gentlemen before me really covered all the points that I would make, technically speaking. But what I would say is that following the 2019 decision in Hilburn in Kansas, our legal system was thrown on its head, if you will, in terms of the court throwing out the legislative caps on non-economic damages. Certainly really opens up the opportunity for predatory trial attorneys to seek pursuing cases in Kansas, and we have seen settlements increase in Kansas following that decision, and certainly judgments have increased. Certainly many of you on this committee probably have seen the growing rise in the number of trial attorneys advertising on TV and putting up billboards across the state of Kansas in light of that decision. So with that as context, we certainly are here today in strong support of this bill. One case one frivolous lawsuit can really be drive a small business owner out of business. We don't have in-house counsel. We don't have the resources as small business owners to fight against these and these predatory practices that are funded by third-party litigants or financed certainly can be a problem for our small business owners. Long story short, this bill will not prevent the financing by third-party interests. It simply allows for disclosure. And so with that, Madam Chair, I'll close and just again issue our strong support.
Thank you. Next, we will hear from Beth Smaller, General Counsel, Kansas Association of Insurance Agents. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Beth Smaller, General Counsel, Kansas Association of Insurance Agents. I apologize for my voice. It cannot withstand the Sunflower Showdown and the Super Bowl within the same weekend. So I'm struggling a little bit. I'll get through this. I'm here today on behalf of KAIA. We represent independent insurance agents across the state of Kansas. We view this issue as being strongly related to affordability of insurance. I'm sure each and every one of you can testify to the rising costs of insurance. I'm sure you see it on your personal auto insurance as well as your homeowners. If you own a small business, you've seen the increase there. Insurance costs have just grown exponentially in the past few years. That is due in large part to social inflation, and social inflation being that rise in insurance carrier costs that goes beyond general economic inflation. That social inflation due in part to increasing litigation costs, which due arguably in part to third-party financing agreements. As previous people have said, we feel this is a pretty low bar. Again, it doesn't prohibit third-party funding litigation agreements. It simply requires the disclosure of it. Right now, we don't track these agreements in the state of Kansas, and so how much dark money is being funneled into our judicial system, we simply don't know. Is this an issue in Kansas, or Is it not? Is this just an issue in states like Georgia, California, Florida, Louisiana, or is it much more widespread than that? I don't know the answer, and quite honestly, nobody knows the answer to that. So this bill is a step in the direction of trying to measure how much dark money is being funneled into our litigation system to see what kind of impact it is having on Kansas's litigation environment. In recent years, again, as you all are aware, we have had record-breaking weather events nationwide, but also specifically to Kansas. For instance, in 2023, Kansas had 2,823 weather events. That number, 2,800, being double what the U.S. average is. And those weather events include severe convective storms, severe hail, and wildfire, simply weather events that are reported to NOAA. Those weather events are going to impact costs. We can't control weather. Wish I could. If I could, I probably wouldn't be standing here talking to you today. But we know we can't control weather. We know we can't control general economic inflation. What we can control is part of the judicial system, and not control it like a puppet master, but just how much dark money is going into it. How is it impacting settlements? How is it impacting jury awards? Those are things that everybody should want to know, because it's going to impact the affordability for everybody within this room. With that, I will rest and stand for questions when you feel the time is appropriate.
Thank you. It's good to see you. Thank you.
Good to see you too.
We know each other from an outside group, but with that, then, we will next invite Rochelle Colombo, Executive Director, Kansas Medical Society. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, members of the committee. I am Rochelle Colombo, Executive Director of the Kansas Medical Society. I'm here today on behalf of the physician members that we represent, as well as CAMCO, which is a medical professional liability company that was started by the Kansas Medical Society and insures the majority of physicians, hospitals, and long-term care facilities in our state. We'll keep this very simple. You've heard from the other proponents about the specifics of the bill and the impact of it. We have supported this legislation several years in a row because Kansas enjoys a very positive liability climate at this time. It is one of the key factors that attracts and retains physicians to our state, which I know is something that the legislature has been focused on encouraging and maintaining the last several years, so that we have adequate access to care for Kansans across the state to the highest quality teams. As has been mentioned by some of the other conferees, we've seen a disruption in the liability climate nationwide due to a lot of changes in the litigation climate, massive awards, and as those trickle down and across states, they do have an impact here in Kansas. One of the things that has created the stable environment that we enjoy is an intentional effort to have positive tort reforms that balance those different factors and make sure that we do have affordable insurance for providers so that they can afford to provide care. So we believe this is really important to maintain that climate, to decrease the outside influence that would encourage litigation and excess awards. And I would simply say we think this is very important to maintain that access, and we would respectfully request your support of Senate Bill 54, and I'd be happy to stand for questions at the appropriate time.
Thank you. Are there any other proponent conferees wishing to testify in support of Senate Bill 54? I'm not seeing any. Committee, you will have at your desks proponent written only testimony from Marley Carpenter, Kansas Association of Property and Casualty Insurance Companies, Philip Arzon, Regional Vice President, Midwest, National Association of Mutual Insurance Companies, Scott Kibbe, Vice President, State Government Relations, American Property Casualty Insurance Association, and Samantha Woods, President, Kansas Association of Defense Counsel. So with that, then, we will open it up for any questions from the committee. Senator Rose.
Thank you, Madam Chair. And this question is for any of the proponents. For a Kansan, when a Kansans feel that they've been wronged and they would like to take the matter to court and they can't afford their own attorney, they don't have the financial means to do that, what other options do these Kansans have to seek justice besides using a third-party financer?
Please introduce yourself again. Thank you.
Yes, Philip Davidson, Hinkle Law Firm. Excellent question. Traditionally, well, since the beginning of really the common law, and certainly as adopted in Kansas, the accessibility to legal services in Kansas is wide open as you could imagine. And you can see that just by turning on your television. There are a vast number of commercials for counsel. Almost all of those counsel will review and accept cases on a contingency basis where there's no outlay of money whatsoever for experts, deposition cost, anything until and if there's a successful conclusion of the case. And so I think the answer is it's 100% open access at no cost to almost anyone who wants to pursue a claim. If a plaintiff were to go, or a aggrieved person went to 6, 7, 8, or 9 lawyers, which sometimes happens, and they all say, you have no case, and they call the number on the TV and get a loan for that, and they still can't find a lawyer for that case, then they're upside down big time. And so I think that the plaintiff's bar in Kansas is exceptional, extremely good lawyers, extremely, in almost all regards, kind, honest people that want to help out their clients. And I think the access issue is one that should not be of much concern to the committee because it is very open access. And I think if you ask the plaintiff's bar or the defense bar, they would both concur with that without this financing issue.
Thank you. I have a brief follow-up question to that for you, Mr. Davidson. Are most of the instances where we see third-party financing of litigation, is it in contingency cases, or is it if you could explain for the committee what contingency case would be, or is it more of the case where you pay your lawyer on an hourly basis for the hours that's worked on the case?
In the vast majority of cases, it's in the contingency side of the case where the plaintiff is, or the plaintiff's counsel is receiving funds to prosecute the case. If it's
When you say receiving funds to prosecute the case, do you mean from the client or do you mean from the financer?
Well, typically, the traditional method is that the plaintiff's attorney firm will finance the case from the standpoint of deposition costs, travel costs, expert cost, things of that nature. That's the way it's always been. I would say that, in my personal view, that the third-party financing industry is an interloper into the traditional litigation system, where they can take a cut without cutting the plaintiff's attorney's fee, which obviously then means that the plaintiff is going to take less or the defendant is going to pay more than they otherwise would. And that's the inefficiency in this finance. I think that the concept that this is allowing greater access is a complete misnomer. And I think that the Judicial Council research will show that. And there's a lot of scholarly research that do show that, if I've answered the question right. I think the vast majority of finance cases, they're contingent cases, and they're just waiting on the side going, am I going to get paid? I have an interest in the outcome of this case. And we're starting to see the same type of thing where certain medical providers will say, well, I'll say they need a surgery and I'll do the surgery, but I want $40,000 for the surgery, when they could go to a traditional carrier that has insurance and maybe pay $10,000 for that surgery. There's no money paid for the surgery is performed, and at the end of the day, they say, I get my $40,000 off the top, and they are an interested party in the litigation, but they're not a litigant. So you're starting to see different industries trying to make money off of our judicial system.
Thank you. Senator Klemp.
Thank you, Madam Chair. I think my question goes to Mr. Stafford or Mr. Davidson. It could be either one. So one of the things, Mr. Stafford, you brought up was the changing of the wording to adding in the term litigation funding. I'm curious, is that just lawyers adding value to that phrase, or is there anything that would be missed as a result of staying with the current language? Or should there be an and/or in between those phrases?
Yeah, thank you. Eric Stafford with the Kansas Chamber. Well-trained, Madam Chair. So, yeah, Senator, good question. I think the intent there and the concern is that there could be third-party funders to a case that are not litigation funders, right? I gave the nonprofit litigation example, and I think the concern from the nonprofit community is ensuring that we're not capturing those types of lawsuits, and clarifying the language that it's a third-party litigation funding agreement versus the third-party agreement is what you'd call more or less belts and suspenders to ensure that it's not capturing a third-party agreement that somebody's providing money to the case, but it's not with the intent to profit like the third-party litigation funding agreements are, if that makes sense.
Just to layer onto that, so nothing would get missed by changing the language to adding in the language you're proposing?
No, I think from the concern from the Attorney General's office, I think it helps them probably provide more protection for the nonprofit perspective. But from our perspective, it doesn't hurt anything.
Thank you. Thank you, Madam Chair.
Thank you. Senator Bowser.
Thank you, Madam Chair. Not sure where to direct this question. Just curious where the 11.1% comes from. Is that a standard legal fee, or where does 11.1% come from?
Did someone mention the 11.1%? Oh, that's a revisor statement. Ms. Scott.
Thank you, Madam Chair. Senator Bowser, that would just be a policy position. So whatever you would want to deem as reasonable for interest. So.
Thank you. Senator Argabright.
Thank you, Madam Chair. Looking over the number of proponents and opponents, a little out of context, but I guess we're the third party in this group. Is there middle ground? I'm not an attorney, but is there procedural type timing things with this that is there a middle ground?
Thank you, Madam Chair. Eric Stafford with the Kansas Chamber. Senator, good question. You know, I have a good relationship with Mr. Federico, who's representing the opponents on this issue and has. And, you know, we met with them via Zoom before our very first hearing on this issue back several years ago. John and I keep talking, you know, would love to try to find compromise. Either you support disclosure or not. That's what it comes down to. They don't want disclosure, we do. I don't know what that compromise could look like in terms of middle ground. I will say that this bill that is before you today is not near as strong as what has passed in several other states, but we're here with this language out of spirit of compromise with the Attorney General's office to address their concerns. But when it comes to the opponents, it's you support disclosure or not, and we can't find what that middle ground could potentially look like. We have had those conversations, but right now we have been unable to find what that might be.
Madam Chair, so Eric, when you say the language from other states is stronger, did I capture that correctly? Could you give an example of what?
Yeah, they require the actual contractual agreement to be turned over to the defense. This is just disclosure if there's a third party to the case, who that would be. This language doesn't require the actual contractual agreement to be disclosed. So I think too, the language that is in there today, you probably have some comments from the Association of Defense Counsel. I think they were going to be testifying as well, or at least written testimony, that they feel like there's too much judicial discretion about the disclosure versus other states, just like under the discovery language, you shall disclose. This is judicial discretion if those certain limitations are met. This is not a nonprofit type of situation or public interest, socially oriented type of litigation. Then the judge can make the decision to allow the defense to see that third party that could be to the case. So I think some states are just, they shall be disclosed. This is judicial discretion, and I think that was the defense counsel's perspective, is they would have liked to see that a little stronger.
Thank you. I see in some of the written proponent testimony that there's a recent survey conducted by a Harris poll. 88% of respondents said there should be transparency of all parties involved in a civil lawsuit. Do any of our other proponent conferees have any information about that, or with the, I mean, obviously we have groups here testifying as proponents, and have there been surveys of others? This says, if you could speak to that for a moment, and then I do have a few other questions.
Sure, yeah, Madam Chair, Eric Stafford with the Kansas Chamber. Yes, that's an insurance industry survey, just I think within the last month and maybe even within the last couple weeks that came out. So we have that, we can get that to the committee.
Thank you. We heard some testimony about dark money. Is there any instances of where foreign adversaries are doing the investing in these types of litigation? And maybe is that the reason the Attorney General was looking at this, or if you know?
Yeah, Madam Chair, Eric Stafford, Kansas Chamber. Get my steps in today. I might just sit in the front row now. Yes, and just being shortness of time, I didn't address that. There is some language dealing with foreign entities or sovereign wealth funds. There are what you guys have deemed the term countries of concern as you deal with foreign land ownership policies. That the concern from industry is that these foreign adversaries invest in litigation, especially in the intellectual property front, so that through discovery they can gain access to sensitive information from defense contractors or others that would allow them to see certain information, proprietary information, that they could either copy or take advantage of. There's been some congressional reports on that. I think we provided that with some testimony last year, that it's become a growing concern.
Is that related to pharmaceutical litigation as well?
I believe it could be. Absolutely, it could be. Anything that deals with intellectual property could fall under that if it can be provided through discovery that the third-party funder could gain access to, again, influencing the plaintiff that they're trying to seek that information.
Thank you. And we heard some testimony about a Supreme Court case here in 2019, and it sort of alluded to maybe, is there any forum shopping going on related to third-party funding of litigation that you know of?
Directly related, no, but forum shopping does happen. But we haven't, I'll say yet we have seen verdicts and awards increase. Are we known for the, California or Illinois-like nuclear verdicts? No, not yet, but that's what Mr. Murray made the point in his comments. Now that we don't have caps on non-economic damages, that is a big concern. And insurance companies will have to adjust their risk exposure through increased premiums to offset any potential risk that could be out there, whether it's a personal injury claim, whether it's a more business-related claim, medical malpractice claim. So that lack of cap on constitutional or non-economic damages will result in higher prices for everybody. So, and just predating that decision, excuse me, I think it was 2014, we worked with the Medical Society, was it 2014? We worked to increase the caps because there was concern that they would become eroded. And so those caps increased. It was a phase-in approach, I think over a 3 or 5 year period, plus an inflationary factor that would allow those to continue to increase over time. But the court said it's unconstitutional.
For those following along online or Could you define what you mean non-economic damages?
Those are well, economic damages is like your actual loss, your salary, a home that's damaged, a car that's damaged, actual loss, and non-economic or your pain and suffering. Phil could probably go more into detail about what non-economic would be. They're, I think, a little harder to quantify.
And one last question. We heard last time we heard this bill that it might impact adversely the little guy who's a plaintiff. Could you speak to that a little bit?
Yeah, I actually had that in my spoken talking points, and then I got to a minute warning, and it's like I'm going to cut that one out too. Yeah, the opponents have said in years past, and I would anticipate that they probably would today, that this hurts the little guy's ability to get into court. I mean, we've been in existence for almost 250 years as a country, and, you know, the little guy has always been able to find a way. I think Mr. Davidson's comments earlier about how they can access courts today in response to Senator Rose's question, they have the ability to get into court. But also, the reason why NFIB is here in support, small businesses can become defendants as well. You guys passed the ADA bill dealing with abusive litigation for your website not being ADA compliant, even though there's no federal standard. That was brought to our attention because one of our members out of Lindsborg that has 5 employees was sued by a plaintiff's lawyer out of New York who had over 800 cases of these ADA abusive litigation. So they can get on the phone and say, you know what, we'll just settle with you for $15,000. And we were able to get a bill passed that created a cause of action. And then that following summer, after that went into effect, the moderated, they require a hearing, I'm going mediation hearing basically before trial in the state of New York. Our members' counsel said, well, by the way, we're going to be filing in district court in McPherson County to sue you for ADA abusive litigation now that we have a claim. And the gentleman said, I dropped my case and I won't have any action against Kansas businesses in the future. So that was a small business targeted today. So small businesses can be defendants too. You know, we get, I believe, unfairly painted that we only represent big businesses, and we have plenty of businesses that are small, independent companies. So I think our agenda is pretty broad across all business sizes. We don't take sides over, oh, well, this only helps big business. But we try to have a good business climate for everybody, because not every big business starts big. They start small and they grow and experience success. So we don't buy into the claim that small businesses wouldn't be able to get into court. If you look on their actual websites, the funders' websites, they say if you have a claim at least $10 million, bring it to us and we'll fund your case. So a $10 million case is not a small case by any means. So I think that's a little bit of a red herring argument.
Thank you. Are there any persons in the committee meeting room or on WebEx wishing to testify as neutral on the bill? Not seeing any. Then we will invite opponent conferee Daiwan Chin Feeman, Director of Commercial Litigation Strategies, Parabellum Capital. Please introduce yourself and welcome to committee.
Good morning, everybody. My name is Daiwan Chin Feeman. I'm from Parabellum Capital, which is a commercial litigation funder based in New York, and we're a member of the International Legal Finance Association, or ILFA, and I'm here to testify on behalf of ILFA. I was here last year. I thank you for welcoming me back to your state. Apologize for the news. The last thing the world needed was for Eagles fans to be more annoying. So first, let me tell you a little about who we are, but I really, in doing so, I'm going to tell you who we're not, because I think a lot of the proponent's testimony here is, to borrow a word from the chamber, a red herring. Who we are is commercial litigation funders. We invest in big-ticket, business-to-business commercial litigation. We do not invest in injury litigation. We do not invest in tort litigation. We are not interested in what interest would be harmed on the property and casualty side of things. We are not opposed to tort reform, and the reason is we're doing big-ticket commercial litigation. For this reason also, we are not interested in suing small businesses. We are profit-oriented. We have investors, just like many businesses, and we have duties to those investors. Those duties require us to invest in meritorious cases that are collectible at the end of the day. Otherwise, it would not be a very good use of our investors' money. So why am I here? Well, obviously, there's a lot of proponents of this bill. I'm here to oppose. I'd like to provide a baseline education to anybody who's interested in it. I know we have a lot of new members to the committee. This is quite a complex issue if you get into the details of it. And I just want to make clear that I'm happy to answer any questions that you guys have, because this is, as I'm going to explain, a lot of what you've heard the industry itself doesn't agree with, and I don't think a lot of what you heard comports with reality. So we're not opposed to tort reform. We're not doing injury cases. We're not doing med mal cases. In fact, insurance often isn't even on the other side of the cases that we fund, because insurance policies typically don't cover business-to-business disputes. Major sectors of our business include patent litigation, which is all in federal court, not Kansas state courts, as well as antitrust litigation, also in federal court, not state courts. These are large-scale cases that cost tens of millions of dollars to prosecute. So the little guy, often, maybe they could find a billboard lawyer on TV to take their car crash accident. But if they need $10 million to sue a Fortune 100 company for putting their small business out of business, good luck finding a plaintiff's lawyer who's going to take that and is going to shoulder the burden of shelling out millions of dollars in costs to support the case. I'll give you a couple of examples. In the past year alone, my fund has helped 3 small businesses obtain judgments in court of $70 million or more against large defendants. In each of these cases, the prosecution of the claims took well in excess of $10 million of our capital to prosecute. These are very expensive cases. They are not supported by lawyers that you see on billboards or on TV. There is a major access to justice gap and need for this industry. We exist out of necessity. Again, we exist out of necessity. And the whole point here is access to justice, which brings me to the issues I'll identify with the bill. First, let me just say that I am a little bit confused by the testimony from the Kansas Chamber. When they were comparing this bill to other state bills, they said other state bills were stronger in that they would require the production of the actual funding agreement. My understanding of SB 54 as it's written is that there are 2 words in the bill which would require the disclosure not only of the existence of the funding, but also the content of the funding agreement. And it's those 2 words and content that would cause a great amount of prejudice if they stayed in the bill, and would de facto ban commercial litigation funding in Kansas. So to the extent the bill has automatic disclosure of agreements, and I think that needs clarification, I'm going to give my testimony assuming that it does. Obviously, if it doesn't, you can disregard many of my points. But to the extent it does, this is the heart of the bill, production of the litigation funding agreement. This is highly prejudicial, and as a result, courts overwhelmingly across the country have shielded these agreements from discovery and lawsuits. Unlike insurance agreements, funding agreements are created after a legal claim is identified. An insurance agreement is a policy to protect you against things that you don't know are coming. A litigation funding agreement says, hey, we have this claim and we're going to fund it. And often, the litigation funding agreement contains highly sensitive work product, including the budgets for the case. Now, insurance agreements are disclosed so we know that there's money on the other side, so we're not wasting anyone's time suing defendants that don't have money and don't have an insurance company that's going to pay for it. The same argument cannot be made for litigation funding agreement discoverability. The whole point of the defendants seeking the litigation funding agreement is to see how much the plaintiff is going to invest in the case so they can outspend them and preserve the historically tilted playing field, depriving the plaintiff of access to justice. If this bill had the content production removed and it were just the existence of funding, that is a reasonable compromise. I was surprised by the proponent's testimony earlier that there are no compromises available. I can think of probably 10 ways that we could compromise, and I encourage the Judicial Council of Kansas to study the issue. We've heard a lot of testimony today about, well, I think when the Judicial Council will study this, I think this is what they'll find. This is probably what they'll find. It begs the question of, why not see what they find? Otherwise, this bill is a solution in search of a problem. Other states have taken the study route prior to legislating. A key example is Delaware, which has a significantly high amount of litigation at state courts due to corporate laws in Delaware. In Delaware, in 2023, the Judiciary convened a subcommittee to study specifically third-party funding in Delaware courts. In May of 2023, they released a long report and recommendation with their findings. I can share those findings with you, but it takes some time. At the end of the day, though, they identified no issue with funding in Delaware courts, where it is exceedingly prevalent. They also said that disclosure could be compromised. There are certain legitimate reasons to have disclosure that our industry supports. To the extent we can have disclosure without prejudice, such as the existence of the agreement and who the funder is for conflicts of interest purposes, that is fine. To the extent the agreement is produced, that is highly prejudicial. We see a clear room for compromise, and it's one that the Chamber of Commerce itself has admitted to. In October 24, Mr. Savol from the Chamber admitted this would be a compromise on the record at NYU Law. In terms of other studies, in addition to Delaware, the United States GAO did 2 studies on litigation funding that you should read in 2022 and 2024. In addition, Texas is currently studying the matter in its judiciary. And the Federal Civil Rules Advisory Committee convened a subcommittee in October of 2024, this year, to study the issue. So active study is ongoing, which is all in response to the solution in search of a problem. It's a reaction that says, well, let's find the problem and then try to solve it, instead of identifying what could be a problem and along the way depriving small businesses in Kansas of access to justice. Thank you.
Thank you. Next, we will hear from John Federico Durst Consulting Group on behalf of the International Legal Finance Association. Please introduce yourself and welcome to committee.
Good morning. Good morning, Madam Chair. John Federico Durst Consulting, here on behalf of the International Legal Finance Association. I'd like to say it's good to be back talking about this issue. For those new to the committee, this is the 4th year that this legislation has been brought forward, and it's never been passed and landed on the governor's desk for a variety of reasons, some of which some of the veterans on this committee can speak to, but there's been disagreement on whether this is necessary legislation. There's been hesitation because of the legislature inserting itself into private contracts, and there's been some concerns with some of the language that's been put forth. Originally, it was painted as, for lack of a better word, an urgent matter that needs to be addressed, and one would assume after 4 years, whatever problem there was in Kansas would have manifested itself. Yet it hasn't. We hear a lot of, this could happen, this might happen, a lot of speculation. I think the previous conferee hit it just right when he said a lot of red herrings. Again, to reiterate, the legislature is being asked to insert itself in a significant way into the contractual relationship between 2 private parties. This is particularly troubling because doing so actually tips the scale. It benefits more favorably one party to a lawsuit, and worse, at the detriment to another. This forces you to potentially provide an advantage to big business, and yes, I'm going to say it, to the detriment of small business. A great question was asked about access to the courts. The issue isn't whether they have access to the court, it's a matter of whether they can stay in the court and proceed. And I always refer back to that 60-minute segment on this particular issue where they interviewed a farmer, Craig Underwood, who had a breach of contract, a small family farm out in California, breach of contract with a big company. He was awarded a $20+ million settlement. They, of course, appealed, and he ran out of money. All of his resources, from second mortgages, family, friends, what have you. But for this option for funding, he knew he was right, he knew they were wrong, and instead of taking 20 cents on the dollar, this was a meritorious claim. And this is what our clients engage in. He then, with eyes wide open, entered into a contract. And he knew he was going to have to give a portion, but he had no other options. So when you talk about access to courts, it's not so much that. On some occasions it is. It's staying in and be able, as a little guy, to fight this issue. If you look at the bill, part of the problems on page 2 Section B, line 21. Those two words, and content, is a slippery slope that funders are concerned about because it might involve work product. And this speaks to some of the troubling language that's in this bill. That language should be stricken. I ask you, when you go down in that same paragraph, to go to line 26. What does this mean when the court is petitioned? When making such a finding, the court must consider the political, ideological, and social nature of the case, the likely balance of litigation resources between the parties, and whether such inquiry would be proportional to the needs of the case and any other relevant information. You're putting this law on the books. Do you have a clear understanding what that means and what they're after? And I'll stay on that page and I will go down to line 33, section C, where they're trying to put a protection in there that says, this shall not be construed to require a nonprofit corporation or association to disclose its members or donors. It does not require, but it certainly doesn't prohibit. Another slippery slope, unnecessarily. The strongest argument we have is that there is already a process in place. If there is a reason to disclose whether one of these funding agreements exists, then the attorneys in the case have the ability to petition the judge in the case as to whether it should be disclosed or not. And the judge is going to make a determination, we would hope, whether there's some relevancy to produce, to disclose. The judge that is closest to the case, the facts of the case. What you're being asked to do is supplant yourself and your judgment on February 10th. In all cases, disclosure is now necessary. And so, Madam Chair, I've raised some issues along with the other conferee. I will offer a solution. Attached to my testimony is language or is an outline of just what the Judicial Council is. In the bill, it says, after the fact, let's have the Judicial Council do a review and report back to the legislature. I offer to you a solution. It's okay not to pass flawed legislation. I offer a solution of submitting this to the Judicial Council prior, and then see if there's a problem, and study what is going on in other states and make a recommendation back to the legislature so you can pass thoughtful legislation. Look at the mission statement of the Judicial Council. They work to improve the administration of justice in Kansas by continuously studying the judicial system and related areas of law by recommending changes that they deem appropriate. Goals and objectives. The goal of the agency is to review the judicial branch of government and the various substantive and procedural codes used by the courts to identify problem areas or areas of potential improvement and take appropriate action. And if you look at the members of the Judicial Council, a diverse group of learned people from across the state, including the chair of both the House and Senate Judiciary Committee. With that, I ask you not to advance Senate Bill 54. Give us time to either work out amendments, you as policymakers make those amendments, or refer this to the Judicial Council. Thank you, Madam Chair.
Thank you. Are there any other persons in the committee meeting room or on WebEx wishing to testify as opponents? Not seeing any, then committee at your desk, you have opponent written testimony from Joseph Molina, Legislative Services Director, Kansas Bar Association, and Callie Denton, Executive Director, Kansas Trial Lawyers Association. With that then, are there any questions? Yes, Senator Shane.
Thank you, Madam Chair. I want to ask a couple clarifying questions just so that I'm making sure I'm tracking this issue. I've heard the terminology both third-party funding and third-party financing. Which is it, or is it both, and which is most common? Because to me, there's a difference. Funding would be completely at risk. Financing would be giving a loan where you expect some recuperation of base cost.
Dywitch and Feeman, Parabellum Capital, and ILFA, thank you for that question. The terms are more or less used interchangeably, but they can mean different things. So our business is what's known as non-recourse commercial litigation funding, which means that basically like a contingency fee lawyer, no win, no fee, basically. And if the case loses, or the defendant's bankrupt, or our plaintiff steals the money, we're out of luck. Well, maybe not the plaintiff stealing the money part, but there's also making loans. This is a lot less common here. If you were to make a loan on a recourse basis, you'd have to be comfortable that the plaintiff is creditworthy. And our business really exists for non-creditworthy plaintiffs. I mean, businesses of all sizes can use our services, but the classic prototypical example is the David versus Goliath. And those cases I mentioned earlier, none of them could have proceeded without the funding or financing.
It seems to me that maybe we're muddying the waters a little bit, the difference between, I think, what many of us would perceive as the really aggressive trial attorney that kind of is the issue of why we've talked about tort reform, certainly for as long as I've been alive. I guess what's the distinction? Are we muddying the waters between what trial attorneys already do and have been doing for decades versus what your organization is doing?
I believe that the waters are muddied, definitely, and I see the confusion. I think there's a couple ways that you can segment this out to organize it kind of in your head and view the regulatory environment. So there's consumer litigation funding, which I think that's what Mr. Hinkle is familiar with, who testified in support of the bill. Consumer funding is typically advances of small sums, 4 or 5 figures, to plaintiffs in injury or property damage cases who need money to pay medical expenses or pay rent until the settlement comes through. It can be pre or post settlement, often post settlement. These are small kind of micro advances that aren't typically used for litigation expenses. There is a large market for that, which implicates consumer protection concerns, et cetera. There are many states that have regulations on the books for consumer funding only. And one way that they draw the line is they say that we'll have an act that orders disclosure of litigation funding agreements, but it's only for cases where the investment is $500,000 or less, because that's a situation where it's likely a natural person who could be where there's consumer protection concerns. On the other side of things, we have commercial litigation funding. So this is bigger claims, typically at least several million minimum investment. It's commercial claims, business to business. Importantly, there's not insurance typically on the other side of these claims, because insurance typically does not cover breach of contract, antitrust, patent infringement, et cetera. So these are not insured claims. They're much larger. They're typically on behalf of businesses or in a business context. They are not for personal injuries. They are not for non-business torts, et cetera. Is that helpful?
Yeah, thank you. And just one more if I can, Madam Chair. Thank you. I will say I think there's some merit in maybe taking some time to understand the context of this problem in Kansas, because I think, certainly myself, I can see the challenges and the struggles on all sides of this argument, and so I think putting some context around that is important, and I do appreciate the suggestions to utilize the Judicial Council on this. One final question. You had mentioned the willingness to compromise on disclosure of existence but not of content. Would that be for a priori disclosure to both the defense and to the judge, or only to the judge?
If it's just existence and there's protections against prejudice, then it can be to everybody. I do want to echo your initial question, though, about prejudice to non-funded parties. A former competitor of ours named Validity wrote an article about this that you can find online, where they say, well, if it's someone who's small, it can be very harmful if the defendant finds out that they don't have money. So I think that is a concern that needs to be thought about carefully, but otherwise, generally, the position of our industry is the existence of funding can be fair game if it's not going to lead to the production of details of the agreement, which could hurt the case. We don't want to defeat the whole purpose of investing. There's certain more legitimate bases for disclosure that I think we can compromise to accommodate. For example, one of the main arguments of the Chamber of Commerce historically has been we need to know if the judge is an investor in the litigation funder. Now that seems highly unlikely and probably not that prudent, but of course we don't want conflicts with the judge either. Last thing we want is to win a case and then have it get reversed on appeal because there was a conflict with the judge. So judicial conflicts, that's important. Knowing the identity of the funder can be important so that it's not a witness in the case who might be biased. And then we're also willing to generally state that, whether or not we have control. We don't. There's many reasons why we don't, including the independence of the attorney-client relationship. We are passive investors. We are not signatories to protective orders. We don't get the discovery in the cases. There was some testimony earlier about getting intellectual property. There are protective orders in these cases that prohibit us from getting any information that's marked confidential, and all of that would be marked confidential. I hope that's helpful.
Thank you.
Thank you. Senator Corson.
Thank you, Madam Chair. I just kind of wanted to reiterate the point that Senator Shane made, because I think I'm in a similar place where I think it makes sense to give this to the Judicial Council to really take a closer look at. So this is the 4th year that we've heard this bill, and I've been asking for 4 straight years for information or data that this is a problem in Kansas, and nobody's been able to present me with any data or any evidence that this is a problem at all in Kansas. I was taking some notes during the testimony. Ms. Smoller says, no one knows the answer of how often or if at all this is happening in Kansas. Mr. Davidson, at one point he said, well, I think the Judicial Council research would show this. Mr. Stafford was talking about $10 million cases. Those are certainly not the kind of cases that we hear in Kansas courts on a routine basis. So I think that we don't want to be in the position of making laws without having any data. And my sense, and maybe the Judicial Council would show that this is incorrect, is that this isn't really happening in Kansas. As you've shown, this is really multi-district MDL litigation. This is massive, complex litigation. And those cases are almost always in federal court. So I think it would be really prudent for us to get some data before we do the legislating piece. I think we should do the data gathering piece first. So I think I'm in agreement with my colleague on that. But I would welcome your input on that as well, because that to me just makes the most sense, having heard this bill now for 4 straight years.
Thank you. I agree, and I think that the Delaware study is a useful roadmap. You can find that online, the website of the Delaware Judiciary. They lay it out in it's a 20-page report. You'll see the PDF is about 60 pages, though. And why is that? Because in addition to having a group of judges examine the issues, what the law is, how other states are doing it, they also surveyed their bar. They said, okay, well, we need to know how prevalent this is, what are the concerns, what are people's actual experiences, and they sent out surveys and they got them back and they analyzed them. They ended up concluding in Delaware, and every state is different, in Delaware they didn't see any issue and they didn't recommend an automatic disclosure regime. The Judicial Council in Kansas may very well reach a different conclusion, but I support the desire to study this because a solution in search of a problem creates unnecessary laws, it confuses people, and it will make this practice off limits in Kansas.
Thank you. Any other questions? Not seeing any. I have a few. Last time we heard this bill, we had a little bit more definition around International Legal Finance Association, which you're here partly on behalf of and partly on your own business. And I think it's a new association that was created kind of right around the time our Kansas law here changed in 2019, maybe 2020. So it's relatively new practice for large firms like Parabellum Capital to be investing in lawsuits. So could you tell us a little bit about ILFA itself?
Sure. Let me just give a little background that the third-party commercial litigation funding industry really started to gain momentum in the U.S. Before 2010. Parabellum itself started on balance sheet at a bank in 2006. Burford Capital, the largest litigation funder, I believe, was formed in 2009. ILFA itself was formed, I believe, in 2020. However, prior to that, there was certainly coordination amongst the litigation funding industry to band together on public policy issues. You typically had the 4 largest funders at the time make submissions, for example, to the Federal Rules Civil Advisory Committee in response to the submissions by the Chamber of Commerce, Defense, and Insurance lobbies. That was Burford Capital, Bentham IMF, now known as Omni Bridgeway, Therium Capital, and I believe one other. Now we have a trade association, but it's new.
Are these capital firms, are they hedge funds, or who are the members of ILFA that are, if it's a public list? I'm not asking for private lists.
What's your definition of hedge fund?
Well, tell us what Buford Buford Capital? Burford
Burford
Capital?
Capital is a publicly traded corporation that funds litigation.
Okay, so
Omni
it's created.
Bridgeway is a publicly traded litigation funder. These aren't hedge funds. They do manage funds. Do you mean fund managers?
Are they created, is their only piece of business to fund litigation, or do they do other things?
Some funders are multi-strategy. I would say that most funders are single strategy and just focused on this.
And you had said that disclosure of the existence of the agreement would defeat the purpose of investing. So what do you mean by that?
Disclosure of the contents of the agreement. So if I'm going to invest in a case, it's because I think it has legal merit, and I think at the end of the day, it's going to be successful. Money will be recovered from the defendant, which will go to the plaintiff, the lawyers, and us, so we can pay our investors. If we funded a case in a jurisdiction where we knew the agreement would be disclosed, the defendant would get that agreement. They would know exactly how much money we've committed to the case, and they would just outspend us until it ran out. It would just get very expensive. It would bog down the courts, but most importantly, it would create an unacceptable risk in investment. We just wouldn't do the case. We would focus on other states where, I mean, there's enough lack of access to justice in the country. We've got plenty to do, elsewhere.
So you said the purpose of investing, there must be a return on investment. So kind of what's the average return on investment in a lawsuit for ILFA members?
I think a lot of that information is private. I will say that, so Burford Capital publicly reports its financials. You can review that. Generally, there's a question of, I guess, are you wondering how things are priced vis-a-vis the consumer, or what kind of return the funder gets on its investment by its own metrics?
Right, what kind of return on investment? Because generally, if you're investing in the market,
Yeah.
stocks and things like that, you might expect a 3 or 4%, I don't know, return on investment. But in litigation contingency fees, like most of these cases are, the contingency fee is sometimes around 33% of what the outcome of the litigation award would be. So is it closer to 33% return on investment?
I would say that the ultimate pricing can be very similar to contingency fees as far as what the consumer is paying. In terms of the return on investment for the funder or its investors, you need to incorporate the losses that occur, as well as the circumstances where we win, but don't win the full amount. And so maybe we get our money back and a little bit more, but not the type of thing where it gets anybody very excited or wants to replicate those types of results.
Does ILFA have any statistics on how often the cases that ILFA members would invest in are profitable versus a loss?
Funders, I don't think ILFA has those statistics, but funders themselves sometimes publish those, and they'll say what's their win rate versus their loss rate. Now, this can get a little confusing because how do you define a win and how do you define a loss? Typically, a funder will define a win as any investment where it didn't lose money. So they could put $5 million in a case and it'll settle for 5.5. Is that a win? That's up for anyone to decide. So those statistics can be a little hard to discern, but generally we win a lot. I mean, we're underwriting meritorious cases. We have teams of lawyers. We're our outside counsel. We vet these cases thoroughly. We spend months typically underwriting a single case, and we invest millions of dollars in it. So we're typically quite successful, although the recoveries, it's still a very difficult business. Litigation is extremely unpredictable, and we do the best we can underwriting meritorious cases, just like contingency lawyers, the best ones out there that are doing well, particularly in commercial. They say you can never spend too much time saying no to an investment.
So you had suggested that the Kansas Judicial Council study this, and if these agreements aren't disclosed anywhere, how would the Kansas Judicial Council go about finding out about them to do their study?
You can read what they did in Delaware, where they did, docket searches in addition to surveying the bar, and I think they got a pretty comprehensive flavor of what's going on. You could also pass something in the interim which would enable that discovery for the Judicial Council, but the Judicial Council only. So one way you could do that would be have a bill which says that disclosure of agreements shall be made to the judge in camera for submission to the Judicial Council. That's one way to do it.
Well, having served on Kansas Judicial Council, if it's not disclosed, it would be hard to determine what the data looks like. Thank you. Are there any other, I think then that's it. We've had all our opportunity for questions, and you have one last one, Senator Rose.
Yeah, thank you, Madam Chair. And thank you for being here. Does Parabellum Capital receive any money from nations that the United States government has declared to be an adversarial nation?
No, we are an SEC-regulated financial advisor. We're subject to numerous rules and regulations which would prohibit that, including the Foreign Agent Registration Act. We have KYC obligations with our investors, and I would say that the majority of commercial litigation funders who are responsible for the majority of investments in cases are also regulated by the SEC.
Thank you. With that, then, I want to thank our conferees. Some of them traveled in from out of state, so appreciate that. And for being here in person, yes, Senator Shane.
One more quick question.
Sure.
Thank you, Madam Chair. Thank you for the leniency there. In the spirit of fair competition, Mr. Federico, similar question that I posed earlier on compromise or willingness to have some kind of disclosure by striking out content or potentially, judge only versus to the defense. Would you just comment on that question so that we have both of your testimony on that?
Thank you, John Federico, Durst Consulting. I appreciate the question. There was a comment made that during negotiations, when we have offered amendments for the other side's consideration, they painted a picture today that we are opposed to any kind of disclosure. That is not the case. We have a system currently in place that the judge, if it's relevant to the case, we're happy to disclose. Not because it's a fishing expedition, not because it may favor one against the other. Let the judge decide. It's a system that is working. We're not quite sure what the problem is, but I'll go back to removing those two words. That would be very favorable to getting us a little bit more comfortable with this bill. But I will tell you that even if you find that this, they shouldn't be penalized because this is a new industry, if you will, over the last 15 years or so. Again, they're born out of necessity. The problem is that it's not this bill. This is a flawed bill because, again, there's a lot of unclear language, and we're not sure at the end of the day what they're trying to get to. So if you think there ought to be regulation in the state of Kansas for whatever reason, and it has to happen the week of February 10th for some reason, then we would ask that you consider amendments to it, but this is not the bill. Thank you.
If I can just add one thing, one other resource that you might consider as you evaluate the issue is a disclosure rule model like they have in the District of New Jersey, which is a federal court, but they have a local district rule called Rule 7.1.1. Requires disclosure in every case of litigation funding, the existence of it, who the funder is so we can weed out conflicts of interest, whether or not the funder can control litigation or settlement, because that could be relevant. And it says that the agreement shall not be discoverable unless there's a showing of good cause following those things. So perhaps something like that could be a good model, which would enable the Judicial Council to get the information it needs to conduct a study. Thank you.
Thank you. And for those following along online, the reason it's the week of February 10th is this is our last week to hear Senate bills before they would be heard on the floor and possibly sent over to the House. So with that then, I want to thank everyone for their attention today, for coming to committee and testifying, and those following along online as well. And with that then, we will close the hearing on Senate Bill 54. And we do not have additional time really today to look at final action on bills previously heard, but do be prepared for those. There are a couple that we have heard that we haven't worked during our time this session. So be ready for those this week, please. Get your amendments ready if you have any. So with that then, the meeting is adjourned.